Hi, everyone. This is a fantastic shift. I've been looking at session. I've been looking forward to this one all day. Before we get going and launch into the papers, I would like to acknowledge the traditional owners of the land on which we stand, the Wurundjeri people. I want to pay my respects to their elders, past, present and future. I'd like to thank them for their expert care of this land, which I love, over many millennium, and acknowledge the theft and the genocide that has occurred where we stand. So this paper is entitled Control at and Within the Border. And, oh no, that's the title of this session. This panel is called Care, Control and Exclusionary Practices. Luckily, there's not many of us here. Papers from the ANZSOC Crimmigration and Border Control thematic group. So you might need to explain to us a little bit more what you're doing. So why don't I just throw to you, Leanne? Are you going to go first? Because there's only going to be 2 out of the 3 papers. We'll have 20 minutes each, and then lots of times for discussion.
I feel like I'm going to sound like someone in a police interview because for the purposes of the recording, I'll introduce myself. I know that everyone here knows me, but my name's Leanne Weaver and I'm the convener of the ANZSOC Crimmigration and Border Control thematic group. And so the idea around our panel today, although not all of us here are members of that group, but each of the original 4 papers had at least one member from the thematic group. And what we intended to do was to showcase the diverse work across people working in what's broadly known as border criminology. And in the original program, there were 4 papers ranging from deportation to welfare-based surveillance, targeted at different groups, asylum seekers, convicted non-citizens, colonised peoples. Unfortunately, we've lost Rebecca Powell and Alison Gerard. They're not dead. We haven't completely lost them, but they're not well, either of them. And so that left us with 2 papers, formal papers, one from Anthea and one that I'll present on behalf of the 3 of us. I'll introduce my colleagues later. And both of them, as it turns out, are on the use of welfare as a technology of surveillance and control and the border-related issues with that. Before I go any further, I want to just halt and give our acknowledgement of country. The authors in this session, so I'm speaking on behalf of all of us, would like to acknowledge the Wurundjeri people as the traditional owners who make up part of the Kulin nations. Wherever we stand throughout the colonised name for this continent, we're standing on stolen land. This country, including land, waterways and seas, has and always will belong with the Wurundjeri Woiwurrung people, and we're on Bunjal's country. We pay our respects to all elders past and present, extending our acknowledgement to all Aboriginal and Torres Strait Islander people, including those who bring their knowledge to this gathering. We acknowledge that sovereignty has never been ceded, with ongoing connection to country and culture remaining strong. So I'll just give a little overview. Anthea Vogl from UTS is going to be speaking about the humanitarian border and its deployment to deter asylum seekers. And I'll be speaking about a paper that I'm writing along with Sarah Marr and Robin Newitt, who I'll introduce a bit more later, on the manipulation of welfare to control the behaviour of Indigenous people. And since we've lost 2 papers from the series, you will still get a very early minute, so don't worry about that. But just to make up a little bit more discussion, Robin and Sarah have agreed to just present an informal discussion expanding on some of the points that I'll be raising. And so, okay with the chair, I'll hand over to Anthea.
Thanks so much, Leanne. My microphone working?
That
better. Okay. Thank you very much to my co-presenters, to Leanne for the acknowledgement of country, and also to the conference organisers for bringing us together and the immense labour it is to organise an event like this My paper today is entitled Outsourcing Deterrence, the Humanitarian Border, Asylum Seekers and Non-Government Organisations in Australia, and it examines the Australian government's direct outsourcing of border control to humanitarian NGOs. It fits broadly within the kind of literature on privatisation of border regulation, but is a little bit of a kind of turn away from that in terms of looking at outsourcing and non-governmental organisations, so not-for-profit outsourcing. The paper addresses two sites of outsourcing: the outsourcing and privatisation of asylum seeker welfare services to NGOs, alongside the role of NGOs in administering the relatively new programs for the private sponsorship of refugees in Australia. And I'm looking at the direct outsourcing as key aspects of both of these programs. In looking at programs for the private sponsorship of refugees and the welfare regime for refugees and asylum seekers living in the community, I'm bringing together two quite disparate areas of border regulation and refugee law and policy to see what comes up when we focus on and centre the role and incorporation of NGOs into mapping regimes of border control and regulation and border violence. The paper draws on the concepts and critiques of humanitarianism, and in particular Walter's theorisation of humanitarian borders as they're operationalised in the context of migration control, to consider the implications of the NGOs operating within the internal border regime. In examining both the provision of welfare and the private sponsorship program, I want to argue that the role of the contracted NGOs in Australia moves beyond what is often identified as a tension between care and control at the border, which is the way this is talked about in work on humanitarian borders and indeed Walter's work. Instead, I think that NGOs are co-opted and captured by the government as direct partners in immigration control and deterrence. And they do this even as they are informed by their own mandates of care, welfare and asylum seeker support. And even as they step into the vacuum, the government created vacuum around the provision of these services for asylum seekers and refugees seeking to come here. Next slide, thanks, Sam. So the talk will proceed in two parts broadly. First, I'll give a quite brief outline of the very growing body of work on humanitarian borders, which analyses humanitarian interventions as enabling and expanding state securitisation objectives. I then present the mix of law and policy and contracts that govern two aspects of NGOs working in these humanitarian border spaces. And I'll first address the provision of welfare to asylum seekers living in the community, and then I'll address the community sponsorship program, which I'll refer to as the CSP, and explain a little bit more in a moment. Before moving on, I think it's important to underline the particular nature of the NGOs that I'm examining here. The status of these organisations is neither as independent humanitarian organisations or independent volunteer-based charity organisations. They have direct contracts with the government. Those contracts are often won not only via open tender, but by open competitive tender, so contracts that need to be renewed on a kind of year in, year out basis, or a 3-year or 5-year basis. And that really informs the argument that I'm trying to make, that these organisations are involved in a direct operationalisation of the border, but with less accountability and transparency than the government for their exercises of control and power. So to turn quite briefly to humanitarian borders and humanitarian governance at the border. So humanitarian organisations with missions to provide care and preserve life simultaneously produce forms of migration control that cause harm and legitimise restrictive immigration practices and border policies. That border policing and humanitarianism are not separate domains of action informed Walter's identification of the border itself as a space of humanitarian governance roughly a decade ago, and work on humanitarian action at the border draws on much earlier work on colonial and post-colonial analyses of humanitarianism as such, and specifically on Fassin's analysis of it as a form of governance that justifies usually racialised state intervention in the name of universalised human life and dignity. Refugee, boat interdiction and turn-back policies have been the focus of a lot of this literature in this space. And Moreno-Lax and Pollister-Wilkins have shown that these violent and deadly policies have been recast as search and rescue missions. They've been rendered as humanitarian forms of governance and intervention rather than as what they are, which are lethal means of control and exclusion. Australia is, of course, on board with humanitarian forms of governments and rhetoric, as most of us probably know, most notably with boat interdiction and on and offshore detention being cast almost ad nauseum as saving lives at sea or as saving lives more generally. Silverstein's work has traced that Australia, in fact, has a much longer history of the use of humanitarian narratives in conception in the space of kind of border control and border regulation and settler colonialism. And there's an intersection between the narratives used in both. And one of those intersections that she identifies is the conception of Australia as a nation of white saviours, where the benevolent care and control is the province and domain of white policymakers. It's worth noting too that outsourcing to humanitarian organisations creates opportunities for resistance and refusals to various forms of securitisation of migration, which is really relevant to those of us who attended the plenary yesterday evening and the screening of Agonistes. It's a topic that really follows on from the discussion of the harms of that regime for the workers within those organisations. And this is also explored in Leanne's work exactly on the provision of welfare to asylum seekers in the community and the idea of the transversal border, that this expansion of the border and integration of the border creates both opportunities for resistance, but also compliance with state securitisation objectives. So to move to the SRSS, which is the primary means by which the government distributes welfare to any asylum seeker living in the community. The delivery of welfare, accommodation, income support, personal casework services and trauma and torture counselling to asylum seekers in the community is undertaken almost exclusively by NGOs contracted by the government under the SRSS. As a result, these organisations become the asylum seekers' principal, albeit outsourced, point of contact with the state and state-funded services beyond the question of their immediate immigration status, which is still managed by the Department of Home Affairs and the Department of Immigration. In the first empirical studies of government contracted NGOs providing SRSS services, Leanne and Alison Gerard challenged the common assumption that these organisations are natural allies of asylum seekers. And they explore how NGOs, and I'm quoting, negotiate the tensions between humanitarianism and government imperatives towards the securitisation of migration. They're quite exceptional, and empirical studies bring to the fore how SRSS providers are directly implicated in delivering the government securitisation agenda and actively shape the translation of government power through humanitarian border work, i.e. they kind of recreate and reshape the kinds of power that government couldn't exercise without them. These are conclusions that I think I echo and very much come out in an examination of the design of these programs. Notably, next slide, please, Sam, until 2011, the Red Cross was the only organisation delivering these outsourced services, and then quite significantly from 2012 onwards, other groups were allowed to competitively tender to provide services, and there are now 8 organisations delivering the program across Australia, including the kind of not ironically named Life Without Barriers. The next slide as well, Sam. The next slide just gives you a bit of a sense of the most recent kind of search of the Australian government tender. And really, I was shocked when I saw these contracts as well. They offer very significant amounts of funding to deliver these services. So all of the NGOs are bound by their contracts, and these contracts include mandatory reporting provisions in relation to their clients' breach of Australia's Asylum Seeker Code of Behaviour. I've written quite extensively on the Asylum Seeker Code of Behaviour, so I'm not going to go into it here. It's not the focus of what I'm doing today, but with my colleague, Elise Methven, we've kind of tried to look at how the Code of Behaviour is policed and enforced, and I will just share one of the most significant findings of that research, that over a period of 2 years, 68% of allegations under the Code of Behaviour originated directly from SRSS caseworkers, so people providing casework to their clients, directly to the Department of Home Affairs, and the consequences for breaching the Code of Behaviour are visa cancellation, redetention into on or offshore detention, and ironically, reduction of income support that the SRSS contractors have volunteered to provide or contracted with the government to provide. So as John Van Cooey, Hirsch, and many others really have shown the SRSS is best understood as a form of deterrence. It's aimed at making life so unendurable that asylum seekers live a life that is structured by destitution and deprivation. And then following on from Webber and Pickering's work on constructed volunteerism, the other outcome that programs like the SRSS seek to achieve is what is called voluntary repatriation, or asylum seekers being unable to live in the community and deciding, in inverted commas, to return home. I just want to speak briefly about some of the punitive aspects of the criteria of the program that the NGOs are required to enforce. And again, Gerard and Webber's work really nicely draws out that these organisations are cast as service providers, but in fact, they play a very significant role in denying services to asylum seekers. So they also enforce people being removed from these programs. The criteria are narrow, they are strictly applied, and most relevantly, they have been even further narrowed by a very punitive set of reforms from 2017 onwards. Most significantly here, the reforms introduced the category of job-ready asylum seekers. As a result, those who were employed or who were assessed as job-ready were no longer eligible for financial assistance, and that was regardless of whether or not they had current employment or any guaranteed prospect of it. And there are a lot of reports of this being enforced against people who absolutely are not in a position to gain any form of secure or insecure employment indeed. The overall criteria for access to the program was determined on the basis of vulnerability. I can talk about how that was defined again, but it was even narrower than the usual criteria for vulnerability that we see enforced in different kind of government programs like this. Those deemed not vulnerable after these reforms were brought in were given 7 to 10 days by their NGOs to transition off income support and payments. And at that point, they were kind of removed from the program entirely. In that period, there was a reduction of about 70% of people who were eligible for the SRSS in total. I think two further ineligibility criteria are really worth mentioning. One is the ineligibility rule, which requires SRSS payments to be ceased if an asylum seeker engages in any post-secondary school level education on a full-time basis. So people would have seen that play out in asylum seekers' access to humanitarian scholarships at universities. And the other is that payments must be cancelled and support must be cancelled if an asylum seeker transfers $1,000 or more to an overseas or domestic bank account over a 12-month period. So people sending money back to their home countries will be transitioned off the program. This criteria was enforced, so the Refugee Council of Australia has reported on the basis of their consultations that this criteria was originally being enforced for asylum seekers who had transferred as little as $50 to family bank accounts. So apparently these anomalies have now been corrected because they were corrected by a policy which set the upper limit as $1,000 over the course of the year. Finally, the SRSS payment itself is indexed to Australia's national unemployment payment, but falls short of it by 11%. So it's 89% of the minimum welfare payment. The gap is, of course, both symbolically and directly punitive in terms of separating out those who are eligible for welfare under the outsourced program. And of course, punitive because Australia's national base welfare payment has been repeatedly assessed as far, far below the poverty line. Okay, I want to draw a line under that and invite you to consider that it is those NGOs in the previous slide that are operationalising this and responsible to government for it being operationalised. I'll now talk a little more briefly about the role of NGOs in Australia's comparatively new program for private sponsorship. I'm really only discussing, so this is a big area of research of mine, I'm discussing one aspect of this program and I'm focusing on the role of NGOs within it. There's a lot to say about private sponsorship of refugee resettlement and particularly the privatisation aspects more generally, but I won't dwell too much on those aspects in this presentation. So the next slide, thanks Dan. For those, it's a little bit lesser known, but also the one after that, jump one, thanks. Private sponsorship was introduced as a pilot in 2013. Thanks, perfect. And was rolled out on a permanent basis in 2017. The CSP was the first program for the full private sponsorship of humanitarian entrance by individuals, businesses or community organisations in Australia. So what that really means is that families or individuals can propose humanitarian visa applicants for resettlement in Australia if they cover the costs of arrival, resettlement and kind of resettlement for the first year of arrival in Australia. Australia's program was unsurprisingly controversial from the beginning. There are a range of reasons for that, but most of all was, well, one of the two main reasons was the exorbitant cost of private sponsorship. So the Department of Home Affairs was charging $19,000 in the form of a visa application fee that went directly to the department, and the sponsors then had to pay the additional cost of resettlement on top of that. So that was a non-refundable revenue raising fee for the department, essentially. It's been reduced under the Labor government, but other aspects of the program have not been reformed as yet. Most relevantly for my purposes today, applications to the Department of Immigration could only be made and can still only be made by what are known as approved proposing organisations, which represent a really significant layer of outsourcing in the programs. These APOs charge potential sponsors on average, their fees vary, they set fees within kind of a range of one another, about $11,000 per application, and that covers application preparation, submission and administration. This is again in addition to those fees I mentioned before. What the NGOs do in their role as APOs is do the first intake and screening of potential sponsors and sponsorees. I think this would be a major form of outsourcing and something that required attention, even if the only criteria for the program were meeting the refugee definition or outsourcing the refugee definition to, say, a UNHCR registration. So refugees had been recognised and registered with the UNHCR. Next slide, please, Sam. However, following the pilot, the criteria were expanded, and now what is required in order to come into Australia under the CSP is that one meets the requisite definitions, but also that the sponsored refugee is aged between 18 and 50, that they have adequate English, and that they have a job offer or skills to enable them to get a job quickly. My next point may come as no surprise, but is the APOs in the first instance who assess, operationalise and enforce the above criteria. And in so doing, they become de facto assessors of refugee status and eligibility under the program. I know I don't have too much more time. I've done an initial set of interviews with the APOs, so I'm trying to kind of draw out some of the aspects of the work that they've done here, but this is quite preliminary work. A couple of points that I wanted to make though. The APOs all expressed uneasiness, stress and confusion about interpreting the additional criteria, particularly the work-ready criteria, which directly corresponds, you'll notice, with the exclusion criteria for the SRSS. They also expressed a similar disease around the English language skill criteria. Because of the absence of any form of guidance about how the employment criteria would be applied, the APOs essentially interpreted this as requiring a job offer to be on foot, i.e. arguably the requirement at its highest possible threshold. So you had to be a refugee under the program, you had to have a job offer in Australia as part of your application to be sponsored. Similarly, there was no further guidance about having adequate English, and a range of approaches were taken by different organisations about what that meant. It was clear, though, that applicants without good English in Skype interviews, and it was pre-Zoom times when I was speaking to the organisations, with the APOs were excluded, so that their assessment of what that looked and sounded like. Or they were told that they should go and learn English and come back and attempt a reapplication down the track. Finally, this screening process was central to the program because in its first years of operation, demand for the sponsored places dramatically outstripped supplies, and APOs unsurprisingly narrated a desire not only to support and take on applicants who had a high likelihood of success because they were undertaking this work and they didn't want to take money from clients and then have a negative outcome. But of course, the success of their applications also had implications for their own involvement in the program and their own kind of outputs and potential for recontracting in the next round of tendering. So I'm not going to do too much concluding, amazing concluding, drawing it all together work, but I do want to say that it's crucial to kind of make the point, which I didn't make so much at the start, that particularly for the SRSS, but also for the sponsors, who are usually people from asylum seeker communities sponsoring family to Australia, they interact with SRSS caseworkers and CSP providers as if they are potentially interacting with independent practitioners or people who are acting without a conflict of interest in their own best interests. And certainly not necessarily people who they imagine have contractual reporting, surveillance or policing obligations to the government. Walters observes that humanitarian participation is part of the regime of border control rather than separate from it. And for both programs, I think the Australian government's approach to outsourcing and these NGOs' participation moves far beyond an alliance between care and control. It aims to make NGOs direct partners in policing, punishing, sorting and excluding asylum seekers, with very much less accountability than state actors, even where state actors have limited accountability in these roles, and in a manner that severely constrains the organisation's own ability to pursue their own mandates of care and assistance, and indeed resistance to government policy.
Shall we hold off questions until the end of the panel? What first?
You want to get yeah. Let's have another discussion. I think there's a lot of crossover between our paper.
How about the little bit?
So I'm the presenting person today, but I want to acknowledge my two co-authors of this paper, Sarah Marr and Robin Hewitt. Sarah Marr is currently the Policy and Projects Advisor at the Naval Justice Centre here in Naarm, and was formerly a researcher with the project that this presentation and the written article that's behind it comes from. And Robin Hewitt is a Thurrow and water woman and criminology lecturer at Western Sydney University, and the Indigenous liaison and advice project. So I was very, very fortunate to have both Sarah and Robin involved in this work, and it's great that they've come today because that means all the tricky questions can be. So the project I'm talking about is the third of 3 case studies from a future fellowship program. It was on, broadly speaking, it was on the policing of internal borders. Something that Anthea was one of the earlier case studies for that program. So this final case study that we're talking about today looked at government control.
Sorry, apologies. So this final case study in the series looked at government control of personal finances through a series of highly racialised policies collectively known as income management. Next slide, please, Sam. So this program evolved over time, beginning with the Northern Territory emergency response, which the Australian folk here will be very familiar with, that imposed what was then called welfare quarantining back in 2007 on designated Indigenous communities in the Northern Territory. And then over time, various other schemes, a very complex array of different arrangements came into place, using different payment systems, having different amounts of a person's income support quarantined. It varied between 50 and 90%, I think was what Sarah found out. So that was placed on a card of some sort and could only be spent in prescribed ways. Noticeably, the latest version involved in the scheme is called the cashless debit card. Well, it's soon to be, we won't have it anymore, operated by a profit-making company that was associated with mining magnate Twiggy Forrest. So this demonstrates very well the marketisation of welfare. These schemes were clearly imposed without consent on entire Indigenous communities in the Northern Territory. So in the first iteration of the policy, over time, there were varying degrees of supposed voluntariness in different schemes, but of course, how voluntary it was depended on the quality of the consultation and the opportunities people had to escape from the the scheme, and spoiler alert, they were few and far between. The Northern Territory emergency response was so openly racist that it required the suspension of the Racial Discrimination Act in the Northern Territory. When Labor came to power, when was that, 2007, they slightly changed the scheme, but they retained the idea, but they revamped it so it became a place-based program that involved both rural and urban communities, but to no one's surprise, Aboriginal people were still highly targeted. So that was really a period of indirect targeting of Indigenous people. Then with the return of the coalition, don't we all remember that? We went back to the near direct targeting of Indigenous communities under various trials. I put that in inverted commas in my notes because trials normally suggest that if there's no evidence that they're successful, that you'll change your policy. But of course, that was never the intention. But we had trials of the cashless debit card, primarily in Sejuna, in Harvey Bay, in the Goldfields, in the Kimberley, all areas with very, very high Indigenous populations. So the overall result across all these different versions of the policy are that it's still predominantly Aboriginal people who are embroiled in these schemes. Public statements made by various governments over time have cited an absolutely bewildering array of behaviours that the introduction of this form of control over finances is supposed to address. And in fact, it's very clear that they're quite complex social problems, from childhood hunger to family violence, to school attendance, to substance misuse, child sexual abuse, problem gambling, use of tobacco and pornography, so-called humbugging, housing insecurity, youth unemployment, and poor financial literacy. We found mention of all of these goals as intended to be alleviated by the introduction of this income management. Next slide, please, Sam. So our empirical research built on two main data sources. The first was a systematic review of policy documents undertaken by Dr. Sarah Marr. I'm very grateful to her for doing that. Somehow she managed to sort out this very complex evolving policy, and she looked at official documents, evaluation reports, commentaries, and submissions to public inquiries. And the second main source we have are some open-ended interviews that were conducted, unfortunately, online with 12 Aboriginal community leaders spread across the country. And they were identified because they had featured in public debates about income management, either in the media or perhaps their organisations had made submissions to important inquiries, and we're very grateful for their participation. The interviews were facilitated by Robin Newitt as the Indigenous liaison for the project, and were conducted by both Robin and Sarah. Why did I say Sarah? I've never in my life said Sarah. The contents page that's shown on the slide comes from a summary report that we developed from these interviews and sent to participants. It just gives you a bit of an idea of the topics that were covered or that emerged in the discussions. We were mainly concerned with the targeting of the policy, you know, the degree of consultation, etc., because that was in line with the bordering theme of the research program. Not so much evaluating success. There's been lots of other work on that. But participants, of course, added comments along those lines as well. Our original plan had been to conduct a more sustained and situated consultation, working with a particular community, probably Sejuna was the one we were looking at, but that became completely derailed by COVID lockdowns. And most of you would remember that Indigenous communities were really national leaders in wanting to protect their elders and locking down their communities way before state governments had done that. So it was just out of the question for us to actually go and work with particular communities, but we did the best we could under the circumstances. So in all, we'll be writing about 3 articles from this work. I won't go into the details about all of them, but the article that we're drawing from today argues that income management represents a form of internal bordering that, while expressly neoliberal in its form and its underlying mentalities, at the same time serves as a central plank in a revitalised colonising project. Next slide, please, Sam. So the theoretical framing that we're using for this argument has three main elements. Neoliberal governance, particularly in relation to welfare provision, the connection between neoliberalism and colonialism, settler colonialism in particular, and notions about internal bordering, which I won't be discussing quite so much today, but we'll cover more in the written paper. So in the article, we draw briefly on Loic Waquant, who's very much associated with the analysis of neoliberalism, who's identified the defining characteristics of neoliberal governance as direct deregulation of the economy, normalisation of insecurity, the promotion of market mechanisms for the organisation of human life, the privatisation of welfare, and the imposition of behavioural requirements for public assistance. The elevation of individual responsibility, sometimes we call that responsibilisation in criminology, alongside reduced state accountability and the casting of poverty in terms of individual moral failure. I think we've all seen a lot of that over the past few decades. Waquant argues that neoliberal governance transforms welfare into a punitive system of surveillance and control, and is part of a bifurcated system that is typically, in his view, liberal at the top and paternalistic and potentially coercive at the bottom. So most of these features can readily be seen in income management policies, but the question is, how is this enacted specifically, or how does this policy specifically enact a colonial system of control, or a settler colonial system of control? So there I've relied on work by Elizabeth Strakosch, to make these connections. She's an Australian political theorist. Have you heard of her, Amy? Yeah, I think you'll like it. I'll just tell you a bit about it. You'll be interested. And she gets right to the heart. I was going to have to try and work this out myself, and I was so relieved when I found her book. She's done a brilliant job of articulating the intersection between neoliberalism and settler colonialism, quite specifically, and in relation to Indigenous social policy, not just welfare policies, but the whole spectrum in Australia. Strakosch sees liberalism as facilitating settler colonialism, as always having had a facilitative relationship with settler colonialism. And this stems from a long history of what she calls imbrication, which I had to look up on Google. I don't know if anyone here knows what imbrication means, but it means overlap, which is very nice for using a Venn diagram. So she argues there's always been an overlap between these two governmentalities, settler colonialism and liberalism. Neither are reducible each to the other, but combine in practice in very powerful and potentially destructive ways. So like Waquant, she notes that neoliberal governance is intensified in some contexts rather than withdrawn, not just the small government idea that is often bandied around. And she uses the idea, this is the core idea, she uses the idea of capacity, which you can see as linked to individual responsibility, to identify, or she doesn't use that idea, she says governments use the idea of capacity to identify who should be subject to governmental intervention. Remember, we talked about that liberal at the top and authoritarian notionally at the bottom, top, bottom. Perhaps that's not a good dichotomy. Anyway, and I'll quote from her now: "Those deemed capable will be assigned to regimes of freedom, while those deemed less capable will be allocated to more authoritarian regimes." And unlike Waquant, she makes this observation: all these regimes are internal to and consistent with liberal logics. Liberalism governs and has always governed through both freedom and unfreedom. So whereas Waquant, for anyone interested in the theory behind it, whereas Waquant sees the authoritarianism at the bottom as somehow external to liberalism and illiberal, Strakosch sees it as very much inherent all the way through within liberalism. So I would see this categorization to steer people into differential treatment and categories of citizenship. And I've heard these arguments several times at this conference about categorization of people to steer them into different types of treatment. So these categories of citizenship, in my mind, are a form of bordering. So that's about all I'm going to say about the link to bordering today. And these, of course, are often determined along the lines of race or indigeneity. So notice that the quote that I just read out before says that liberalism has always governed this way, but with some variations over time. So Strakosch identifies the era of classical liberal rule, coinciding with the historical protectionist era. I think most of the Australians here would know, the period covered by the protectionist era of colonial politics, as literally and comprehensively excluding Indigenous people from legal citizenship on the grounds of incapacity. So that was a period at which citizenship was openly denied to Indigenous people categorically. In contrast, present-day neoliberalism engages in strategic and fluid exclusions. There's always the option to redeem citizenship status through behavioural change in conformity with neoliberal expectations. Assumptions about, 3, 4. Got there? Okay, next slide, please, Sam. So this is a really crucial point that gets us to settler colonialism. As Strakosch explains, and I quote, in the transition to neoliberal logics, there's a complex rearticulation of the terms of Indigenous exclusion in the settler order. Indigenous people are nominally included as citizens. We have that facade, but this inclusion is detached from the permanent attribution of capacity. Instead, Indigenous people must constantly perform this capacity or face coercive regimes within the framework of liberal inclusion. Moreover, this governmental technique can easily be presented in ways that maintains an appearance of racial equality. So the NTER being a notable exception where the coalition made no pretense that it was racially equal. But at the same time, this technique easily reconstructs racial categories as statistical clusters of risk, threat, and incapacity. So hiding the colonial and racialised nature of some of these policies. And so we arrive at the narrative of Indigenous deficit, driving policy under neoliberal governments, driving Indigenous policy in particular under neoliberal governments, and justifying highly racialised interventions, of which income management is a prime example. In the written paper, we'll be using data from official inquiries, policy documents, and the views expressed to us by Indigenous leaders to demonstrate in more depth how income management enacts these modalities of neoliberal colonial governance and creates internal borders between supposedly capable and incapable citizens. We don't have a lot of time to talk about that today, but after I finish, we'll have enough time, I think, in our session, because we've lost 2 of our papers, that Robin and Sarah will be available to talk more informally and expand on that, talk from their experience of speaking with the Indigenous leaders. Next slide, please, Sam. So it's important to note, I'll just summarise though, that Indigenous leaders who spoke with Sarah and Robin, even those who'd initially given the scheme some qualified support. So we didn't, intentionally just speak to people who were critical and opposed the scheme. We tried to get a bit of a mix. Even those who initially had some support identified the paternalistic, the stigmatising, the regressive and controlling aspects of income management. And all of them were acutely aware of the historical continuities and saw the scheme as the antithesis of self-determination. So this statement, this statement that's up on the screen now, from a participant who was working in an Indigenous-led organisation, illustrates many of the key themes from our analysis. So we'll just make do with this one statement at this point. She told Sarah, it was in this case speaking with her, that income management had never been intended to achieve the objectives stated by governments, but it had the opposite effect. If you focus on the words in italics, you can see that assumptions about incapacity, and there she uses a remarkably similar concept to that was used by Strakosch, have been used to justify paternalistic policies that take matters out of Aboriginal hands, that there are historical connections to earlier colonial policies that controlled income and other aspects of Aboriginal lives. And the speaker links this to a form of lesser citizenship. So she's really incorporating, she's a great theorist, she's a fantastic theorist. She links it to a form of lesser citizenship, echoing the days when Aboriginal people were not considered citizens at all, so that classical liberalism. and confirms that this policy has always been about control, as with earlier colonial policies, rather than working with Aboriginal communities to resolve problems arising from colonisation. Last slide, please, Sam. So just to finish off, I thought we'd finish a little provocatively. Can income management be decolonised? So we don't have a lot of information on this, but one article in the Saturday paper a few months back argues that while the incoming Labor government moved very quickly to lock out private providers, such as the Indue card, Twiggy Forrest's crowd, from managing the system. So that was done and announced very quickly. So this wound back some of the excesses of the marketisation of welfare. They've retained, so far, we're a little bit unclear now to what extent, the government administered basics card, which has overwhelmingly been imposed on Indigenous people. So this commentator, at least, Sarah's done a bit more research on this and we're not sure whether he's got it quite right, but it certainly looks on the surface for now that it seems that not all welfare recipients, as foreshadowed, will be transitioning from compulsory schemes to voluntary options. So the present changes will, in his view, return income management to being almost exclusively for Aboriginal and Torres Strait Islander people. In short, the incoming Labor government, interestingly, has been much more anxious to deliberalise, if you like, demarketise the policy rather than decolonise it. But we have to see how this unfolds. We might be missing a bit of detail there. So income management may persist in close to its current form. We're yet to see how voluntary the voluntary is as a highly controlling, divisive and racialised mode of welfare provision. And if this indeed is the case, this demonstrates the continuity and ongoing entanglement of neoliberalism and the settler colonial project. Thank you.
Okay. All right. So Robin and I are just going to give you a little bit more information. I'm going to update you on where it's at now. So I'm assuming that people don't have a lot of knowledge about this. So just a little bit of background context. So in the Northern Territory, people are under the basics card. It's across the whole of the Northern Territory. Initially, it started in various remote communities, Indigenous communities, but in order to not appear too racist, they spread it across the whole of the Northern Territory. So there are currently 24,000 people on the basics card in the Northern Territory. In 2016, they gave it another shot. They introduced what was called the cashless debit card. Now, this came from Twiggy Forrest, one of Australia's most wealthy men. He, for reasons that are not clear to me or probably anyone else, was asked to do a review of Indigenous employment, and he came up with a scheme to redesign welfare. His plan was that you should have the cashless debit card, so 100% quarantine of money, so no cash whatsoever. It shifted from that when the trial actually began, and I don't think many people know this. I really stumbled across it when I was very deep in the tunnel of the paper trail about trying to understand how this thing came about. And a group of elders and community leaders in Ceduna, which was the first trial site, talked them down from 100% to 80%. They said, you want us to do this? We do it. We start at 80%. So that's the only way it actually changed from 100%. So the basics card is 50%. The cashless debit card is 80%. So started in Ceduna, spread to WA, to the Kimberleys and various sites, and then into Queensland, into a couple of sites. Supposed to be a 1-2 year trial, still operating until the end of 2021 when the Morrison government tried to force it through into a permanent policy. They failed. Labor's come in. Just before the election, Linda Burney said that the only way it would continue is, communities could continue with it as a mandatory program if there was full consultation and communities wanted it. Other than that, it would be voluntary. So since then, that legislation has been brought in to scrap the CDC system. So as of October 4th, if you were a participant in the cashless debit card, you could choose to opt out. So this is what happened in South Australia. 6 days later, half of the 12,302 people who are on the trial in South Australia had opted out. In Queensland, Bundaberg and Hervey Bay, 1,813 people, just over 4,000 had left, and in WA, 45.9% of the 2,459 people on the scheme had opted out. So in total of 17,000 people on the trials, 41% had opted out. So in terms of what happens next, the plan is a new voluntary income scheme, and as of March of next year, if you're still on the CDC card, you can choose to opt into the voluntary system. And then in July, if you're on the basics card, so if you're in the Northern Territory, you can also choose to either opt out altogether or opt into the voluntary system. There's still a bit of mystery around this notion of communities who might want to continue with a mandatory scheme. So that just remains to be seen. I don't know if that's going to happen with any communities who would actually willingly agree to that. Like Leanne said, those that did appear to agree or consent to the trials in the first place, that's highly contentious. And those, at least one person that we spoke to said he did agree originally because he thought it would be an answer to what was a serious crisis of youth suicide in his region. But once it kicked in, they lost all control of it and they weren't allowed to direct it or influence how it operated. So that's where it's at. So it's kind of watch this space to see what happens next. Thank you.
So I guess for me, I'll just present some of the findings that we got from the elders that we spoke to, or community members that we interviewed via Zoom or on the phone, which were quite tricky at times because it's very difficult to hear them talk. Plus, you know, we all did the whole home COVID stuff, so everyone was home and noise in the background and kids running around. Leanne spoke a little bit about the Aboriginal Protection Acts and the provisions that Aboriginal people were forced under those acts. Now, just to give a little bit more of a background into the historical context of that, without kind of boring you too much, but I mean, I think they're fascinating. I love them because they're quite ironic. But some of the elders were talking about like relating income management to the provisions, and she was saying that some of her family members who were under those acts, this is like the same kind of thing happening. And her quote was, you know, that's what happened to my grandfather, great-grandfather and my mother when they lived on Palm Island. They were under the act where everything was governed for them. So they were given the rations and they never actually received their money that they worked for. Now, under Aboriginal Protection Acts, the Board of Protectors or the Chief Protector would dictate where you would work. So you would get a work agreement wherever it was, whoever it was with. You know, most times we know that it was unsafe for Aboriginal people to be working out in certain places, and these the income that would, you know, normally go to the person who worked were put in trusts, which were the chief protector or Board of Protectors, depending on state, territory, held. So it wasn't until maybe the late 30s, early 40s that pocket money was given to Aboriginal people. So a small percentage was given to Aboriginal people to spend as they saw fit. So similar to, very similar to the cashless card debit system where 80% is quarantined. You can only spend it at certain places and then 20% is given in cash. So super similar situations there, or relations there. In relation to borders and restricting movements, they were provisions as well under the Aboriginal Protection Acts. Aboriginal people were forced onto reserves and missions that weren't their country without a say. And 3 elders from different jurisdictions spoke, about how restricting this card is, and it controlled Aboriginal people's lives, very similar to the policies of wage control, which, as Leanne said, it's abusing fundamental rights of self-determination and a repeat of past provisions. So one elder said they've taken so much off us and now they want to take our right to spend money. They just want to give us a card like it's old mission days again, and I'm sure a lot of other people feel that way. Another elder said it's more going back to the old ways where it's them telling us how to run the program, so do this and do that. So that's all because there wasn't the consistency in there on how to deal with the card and what communities were asking for. Another elder was saying that we've been putting up with crap from the government for a long time. They tell us what to do, how to do it, and where to live, how to speak. They're taking all rights away from us and our traditional ways and culture and language. And when we did when the consultations were undertaken, which consultations is a dirty word for Aboriginal people because we know what that means, there was a lot of kickback from the people that we interviewed because, evidence of consultations kind of occurred in a tokenistic nature. So some people were not even aware that the consultations were happening until that morning or later on that afternoon. It was too late to organise family members to look after kids or to feed, whatever. So they weren't able to actually attend them. But I think one of the interesting things is one of the elders we spoke to. I'll just read their quote because it's really good. Whilst it was marketed as consultation, it was very much, here is a fact sheet, this is what will happen, this is how it will impact on your community, not so much, here is a two-way conversation in which you can put forth your ideas or views and talk about any of the risks that you see with this in your community. So those consultations were very much controlled by government services going out into those communities. There was so many different quotes on consultations. One of them mentioned that they don't listen to anything that we say, they don't take anybody's concerns, and they go around and they have these community consultations and the like. That's it. Like that's what they say goes. Not sure what else I can bring. I think that's pretty much it. Oh, actually, let's do a Twiggy Forest one because they're always fun. It was a room full of people in one of their large conference rooms, and Twiggy was at the front with his entourage. And it was quite a large room. It would have been 700 people in the room, and a number of whom were raising concerns and issues. And his response at the time was, "Can you give me a one-pager about that?" Literally, he was kind of throwing that around. What do you think the answers are? Give me a one-pager about that. It was an absolute farce of a consultation. And when we interviewed these community members about consultations, it was pretty clear they were done in tokenistic natures. So one of the biggest, I think, issues which is coming out of Labor's, response to abolishing the cashless debit card is this voluntary. What does it mean? So that's going to be something that we're going to have to be keeping an eye on, I think. But moving forward, this project, I know we spoke to this community in Sydney, and they really wanted us to kind of go there and have a talk about the cashless debit card system, because not many people know much about it, even though they're being forced onto it. So I think one of the biggest things for us is just getting this information out to community, because we've got their knowledge now, which is very important. Not only they shared it, but what we do with that in representing their voice adequately and correctly. So I think moving forward, that'll be a good, response to, and maybe finishing this, future fellows that you've got here, to starting the work and then finishing it in a really kind of natural, kind of organic way, but also very respectful. So yeah, I think we're on a good path. We'll get there.
I'd just like to add something else, and it's about the way this policy was evaluated. So there was, just so we're clear, that the evidence about this was very dodgy, but that didn't stop them. So the first evaluation was considered so methodologically flawed that it was roundly dismissed, except by government when they chose to use aspects of it that made some kind of statement that they could use. A second major evaluation was brought in because of how flawed the first one was. And that was available at around the time of the legislation to try and make the policy permanent, but the government wouldn't release it. And we all know what that means. If it had something good to say, they would have released it. It would have been on the front page of, you know, all the media outlets, but they didn't do that. It was released sometime later, and again, it failed to prove any real hard evidence that was useful. And finally, the Australian National Audit Office did release a report just in June of this year, the second that they'd done on the card. The first one was in 2018. And they said, once again, the government has roundly failed to prove over a 5-year period that the policy works. So I just wanted to finish on that note.
Everyone, that was just really fantastic and completely interesting. Questions from the floor, or are there any questions from online? I can run this one around.
Thank you all so much, and a million questions, and it's just, yeah, both you all did such a good job of showing the intricacies, I guess, of the violence of government control. But my question is for Anthea. Yeah, it was such a good, I mean, awful, just awful. But I was wondering particularly about the things you're talking about with the, what are they, it's SRSs, sorry. RSS. Yep. The examples you gave of things that they're looking out for, I was wondering about ones that are particular to children. And I guess both so-called like unaccompanied minors or kids who are here without, where the minister becomes their guardian, or kids and families. And I guess there'll be stuff around, I'm guessing breaches of school attendance. And but yeah, I just wondered if you could speak to that a little bit.
Yeah, I should have qualified. I was focusing. So there are 6 bands of, thanks. No, just there are 6 bands of eligibility under the SRSS, and I mean the eligibility criteria that I was mentioning essentially applies to the band 6, which is where most of the SRSS is distributed, which is to adult asylum seekers living in the community. But then there are a range of other, there's a particular ban for unaccompanied minors, and there's a ban for unaccompanied minors depending on, and it varies depending on whether or not they have a residence determination or whether or not they're living in community detention. In looking at the eligibility and ineligibility criteria, I haven't seen anything that shows that the program, that it differs around particular children who are in the other criteria bands, but I can't say that with certainty. What I can say though is both my conversations with different refugee sector organisations and actually Leanne and Alison's work revealed the ways in which SRSS providers were reporting on things like truancy, so kids not attending school, kids being expelled or suspended, as a breach of essentially the code of behaviour. So they were coming in under kind of breaches of that they had to comply, breaches of either their visa conditions or the code of behaviour, as then either not being reported to the government or indeed reporting misbehaviour of children to the department. I'm not sure that those things tracked directly around the eligibility criteria for the SRSS as such, because I think they fit more neatly. I think they fit more under kind of general reporting or enforcing the code of behaviour. But I'd have to look into it. I just haven't, in looking at the eligibility criteria, I haven't seen the differentiation between the bands.
Sorry, this is nothing to do with your, nothing to do with your question, Geordie. It's just that I thought of it as Anthea was speaking. Even the name, when Anthea was spelling out the name, status resolution support system service. It's been a while since I did it. Service, yeah. When you think about that name, status resolution is what it's about. It's not about supporting people in the community. It's about status resolution. Doesn't that reinforce that it's all there to bring about an outcome that the DHA wants to have, which is for people to withdraw, hopefully, or if it's going to be a successful asylum claim, that's reached fairly quickly. Yeah,
it's an ambiguous space, that term, isn't it? Because status resolution, you're on that payment, your status hasn't been resolved. So it's classifying you as not yet classified. In limbo by definition.
Yeah, there's some work done in the Scandinavian states, and it's Richard Cox, a paper that he's published quite recently. There are some of these equivalent status resolution services, and the organisations have to commit to getting people who they're distributing welfare to, they have to commit to kind of taking responsibility for their status being finalised, either being granted a visa, but by implication, really deportation and removal within particular time periods as part of their contract with government. So that it's kind of explicit. They're taking on kind of the government role in hastening kind of the status resolution or deportation procedures, really.
Oh, Ashley's behind you.
Hello?
I'm being a terrible chair, but the end of the session.
I was just interested in what the well, interested in all of them. They're all really saddening, eye-opening, but really important to hear all of the details that you went through. But I'm also interested, I suppose, in how the theory, some of which you elaborated on, Leanne, can be applied to explain some of these sort of contemporary regimes. So, particularly, I can't remember the name of the theorist, but the woman that you cited who'd articulated the sort of continuous relationship between authoritarian and liberal regimes of governance. And so I've sort of come across some work that speaks about the sort of Lockean ideals born out of settler colonial Australia. But I was just wondering if you could say, I don't have a really specific question, maybe just a bit more about the economic dimensions of that and how these more flexible regimes through these neo-colonial policies, what they're historically maybe continuous or different dimensions are relative to those earlier liberal forms.
Well, Strakosch, so that's the name of the theorist. She makes I left out a bit of a historical gap in the middle there. I'll get to that in a sec, but she talks about there's a continuity right through, but she talks about the particular similarities between classical liberalism, so very laissez-faire liberalism, and the market-driven, deregulated neoliberalism we have now. And I guess on the economic side of it, I think Robin kind of explained that really well about how control of economic resources, financial resources, was really seen as a strong governmental tool back in the days of the overtly racist and colonial protectionist legislation. So that's always been a lever, that strong financial lever to control movement, to control liberty, to control a wide range, whole lives really. Of course, there are other types of control that weren't necessarily financially mediated, but that use of control of finances as a governmental tool is just so typically neoliberal now as we understand it, and was also very prevalent around that classical liberal time. The little gap I missed out because I didn't want to take too much of a detour and lose my argument, but the little gap in between that Strakosch calls, let me think what she calls it. I think she calls it social liberalism. I think most of us would maybe call it social democracy or even sort of welfare liberalism. But I think she wants to kind of say in Australia, it's always been liberalism of one kind or another. So the post-war kind of social liberalism, as she calls it, where you know, there was a little bit more of a commitment to larger or government providing support for people. That was a period in which Aboriginal people were formally recognised, I guess, and came within a citizenship framework. And it was a period of marked more by universalism. I mean, we can argue about that, you know, not perfect, but that was the impression given, was that it was there were more universalist approaches. And that's also the time, and I can't remember exactly when, that Aboriginal people became eligible for federal social security payments for the first time. So there's that financial economic link again, and that was universally available. Whether everyone got it, I don't know, and not linked in these quite disgraceful ways to behavioural change or anything like that as it is now. So we see that has changed now under the neoliberal kind of regime. Just importantly, this is not so much the economic aspect, but just so I don't misrepresent Jakosh, she doesn't say that that period of social liberalism or social democracy was some kind of golden age when there wasn't colonialism anymore. She basically says that universalism was just a different way of incorporating Indigenous people into the state system. So citizenship was still a colonising tactic, but just a different one from what we see now.
It's so interesting to sort of see the evolution of how that control is maintained, and as you speak about a lot of the practical monetary sense, but also through these broader regimes that are used to justify it. Thanks.
Is there a question online?
Oh, I was just going to ask a question if that's okay. Yeah, I think eye-opening is such a fantastic word for the presentations. One for Anthea. I know you kind of mentioned that in the interview, some people had sort of an uneasiness around their role. Did that ever did they fully understand the complicity of their organisations within that system? And I guess tying into Agonistes from last night, where a lot of those practitioners really did understand that complicity and had mainly chosen to remove themselves from that. Did that come up at all?
No, I mean, the short answer is no. Right. It's a kind of question to ask the data in some ways, or to really sit with some of the interviews and see how, I guess, the dis-ease or disquiet is expressed by participants. But I do think, I guess, coming back to some of the comments that were made at the plenary session last night, and the way in which the institution or the organisation becomes the main point of reference for people's, I guess, self-justification. In some ways, I think a lot of the participants of the APOs, I think, is less vexed than some of the SRSS organisations. So they're not kind of necessarily directly reporting on sponsors and sponsorees to government in the same way. So they're in less of an invidious position. But I think they still saw their role as facilitating the entry of asylum seekers into Australia. They see themselves as performing a humanitarian function, and some of these things as conflicting with that. I don't think there wasn't a level of discomfort that kind of superseded or took over the sense of, I guess, a simultaneous view that they were doing kind of good humanitarian, morally righteous work in facilitating these programs. There certainly wasn't a critique. What I thought was interesting, I guess they're organisations that have always worked in partnership with government, but there wasn't a sense that this work shouldn't be outsourced, or that there should be greater transparency for the work that they were doing. And in many ways, you know, they're organisations that generally provide also government contracted settlement services and broader service provision, and I think they saw their roles within that context. There were other aspects of the APOs doing this work, which questions recorded, but I think it's okay. It was in these interviews. They were enforcing kind of priorities that government had around sending countries for refugees. in a way that I think troubled them more. So adopting kind of government policies about what should be our primary, what states the government should be prioritising for our offshore humanitarian program. I think they saw that as more in conflict with the mandates of their organisations.
Do you want to ask me? May I? Yeah, just I was maybe I'm just wondering, sorry, if the UNHCR and IOM, if they have any role in the Australian border regime, or if they are completely absent, because you mentioned some key roles, and I was like, yeah, but in this context, is IOM who do as an actor doing voluntarily return, or UNHCR doing like the cash to the system? So yeah.
I can answer. Yeah, so the IOM is one of the APOs under. So the IOM has a range of roles in Australia. They absolutely they do a range of things, but under the private sponsorship program, they are one of the intermediary organisations. So they got one of the contracts to facilitate private sponsorship. The UNHCR, interestingly, I think a lot of other private sponsorship programs outsource the refugee status determination to the UNHCR. So Canada, that's had a private sponsorship program in place for a very long time. A refugee has to have UNHCR registration in order to be privately sponsored. Australia, in its kind of usual adversarial posture towards international law, conducts its, I mean, if you have UNHCR registration, obviously that means that you have a stronger application, but it conducts its own refugee status kind of assessment, light, I would say, like not a particularly good, are there any good refugee status determination procedures? No, but they conduct one at the kind of relevant embassy or where the Australian government is located, and they don't outsource to the UNHCR the kind of refugee status determination. We do that though with our offshore humanitarian program more generally. So people who come in under the non-privatised program, there's a part of that program which accepts UNHCR registered refugees. So the UNHCR is incorporated into our kind of offshore humanitarian program in that sense.
Yeah, thank you.
Asked a question about I just come out.
Here we go. Got it. Got it. Sorry, everyone. Tech fail. I'd like to ask Sarah and Robin, that was really great and insightful. Thank you. Can I ask you a little bit just about the politics of what's going on with the Labor Party and the decision not to completely abolish these welfare cards, but to keep the door open? It seems to me that all the evidence is that it should be abolished. But then, interestingly, when you said the statistics about the people who left the welfare card in the next week, there was a lot, half, but half stayed.
Just to clarify.
There's a switch. Maybe push it up. There's a switch.
We don't know what's happened since the 6th of October. There may be the other half is left.
Okay.
Yeah, so we can't assume that it stopped. Yeah, and the process of leaving involves some engagement with a government body. So that's a lot of applications to process. So I don't know where it's at. I don't know if we can actually find out at this stage where it's at as well, because we're only, 6 weeks down the tracks. But yeah, we can't assume that it stopped. I suspect it's just kept going.
I mean, you asked about the politics of it, which I don't know. I find it
What's
really
going on with Linda Burney and that?
I can't talk on behalf of them, and I probably won't on while it's being filmed. But like for me, history is important. So I always link it back to Aboriginal Protection Acts, because like you asked about theories, you know, my theory on this is just same shit, different bucket, right? It just keeps going. Same thing. It's just repetitive and it's kind of a bit boring now, but there's a government obsession with controlling the lives of Aboriginal people. It doesn't matter if you're Liberal or Labor, clearly, because as you said, there's all the evidence points to this is completely a racialised targeted policy that has no impact on improving the lives of Aboriginal people, let alone their community. And why they don't abolish it altogether? Well, you know, it's got to serve the colonial purpose, right? It's got to serve colonial systems and the colonial government, because they're the ones that have the power. So, you know, you completely abolish it. It's like public drunkenness laws in Victoria. We're still not there, right? Like, it's still not being decriminalised until late November next year. So all these policies that are racially targeted towards Aboriginal people, because we're not the majority, we don't have the power. You know, our story is not as important or placed in a higher priority to other areas. You know, whatever is going to serve colonial government's interests are going to be centred. So keep it open just in case, because we want to pick parts of it that are going to look good and make us, you know, seem like we're doing the right thing or something. Like the Racial Discrimination Act is still not completely being re-implemented. I think that's the right word. I don't know. It's reinstated, yeah. And they've had since 2007 to do that, and they haven't. So, you know, it's just politics. It's just how they work, right? Like, it's a system.
Yeah, and I think it's a warning in case people forget that how far governments are willing to go to enforce that type of control. So Labor is deeply implicated in that 5 years of the CDC and going back to 2007 with the Basics Card. It wasn't just the Liberal government, they were both deeply involved in maintaining that system. So, you know, like Robin said, that their foot is still in the door, and just be very careful or watch what's going to happen next, because they almost made this a permanent policy. It only failed by one vote.
Could I just also pick up, Amy, you're very astute there in how you've expressed this, keeping the kind of bedrock of the legal framework in place. And you know what it reminds me of? Labor's got form on this with offshore processing. So what happened around the time of the Houston panel and the attempt of Labor to have slightly more humane, maybe, border policies was that the outcome of the Houston panel was to temporarily stop using offshore detention, but they kept the legal framework entirely in place. And then so as soon as, because what they did was not effective, and as soon as boats started arriving, which they're quite entitled to do, but as soon as that became a political problem for the Labor government, they just fell back to that fallback position of opening up the detention centres again.
Probably, look, maybe the last one.
Hi, thank you so much for both of the papers. I actually just wanted to pick up for something that Robin, you were just saying, when I think you said all the evidence, but I might have misheard you as elder evidence. And I was going to ask you, actually picking up on, you know, what the elders had told you in the interviews and they're theorising the history as well. They're theorising that they're actually providing lived evidence. So I think my question is around, yeah, how are you, I'm interested to understand how you're weaving in the stories and those histories within whether it's within particular papers that you're publishing, or yeah, how you're holding those stories and where their voices are being positioned in the work that's being produced.
Yeah, no, great question, because it is really important that we, because we've got this knowledge, right? We've got this, these experiences of Aboriginal people, and, you know, for 234 years, we've been researched as scientific freaks. So, you know, to contribute more to that, for me personally, was very difficult to place myself in, but this cashless debit card system, you know, for them to be able to actually have a platform to express how they feel and express what it's done to their community and how it's just a repeat is really, it's necessary. So the stories that we've got, you know, we've done an exemptions paper and related it back again to the Aboriginal Protection Acts of applying for exemption and applying for exemption out of the cashless debit card system or basics card. And the relationship between the two, I think that, you know, the quotes and voices that we've got in those articles, especially in this one, there's quite a lot of those, I guess, the knowledge, the Indigenous knowledge is a lot. This one more so than the others, right? Like, which is important, but going forward, you know, it's also about that relationship building, maintaining and retaining with these community members, because like Sarah said, we don't know what's going to happen. This is only early days with Labor government, you know, abolishing it and picking parts of it to keep. But we need to be, you know, maintaining that relationship and communication, because look at, we're here now talking about it. They're not, you know, we're speaking on behalf of them. We're using their knowledge. So for us to get that right in the papers is necessary. But I guess probably, I don't know, I mean, it's difficult for me to go through these transcripts constantly and having to, because my mum was born in 56, so she wasn't even a citizen of a country she was born in, you know, in her ancestors, 65,000 plus years. So to hear them, I don't know, it's just a painness in what I read. So I like that we've, you know, there comes that, you know, obviously the laborsome and the burden of making sure that we don't misrepresent them. But I think because we're aware of that's not going to happen. But with definitely things that they've said, stories that they've shared as well. I mean, for me, will stay forever. I don't know, I'm sure with you, Sarah, as well. But everything we write, everything I read, anything to do with cashless debit card, I'm always automatically straight back. You know, what did that elder say? What did that elder say? So it will always, you know, remain with us, but just being able to express them through any articles that we write. See what happens going forward there, right? Yeah.
Can I just add to that, in the talk I said we were planning to write 3 articles from that information. The first is the one that Robin just mentioned, where we looked at exemptions and how people could escape out of the system, which wasn't very easily. The one that we talked about today is still evolving, but as I was preparing this presentation, actually, I became aware of how theorised this one was getting, and it's quite driven by the theoretical framing. Elizabeth Strakosch, I've become a bit of a fangirl and relying on, you know, quite a bit of her work. She's not Indigenous. She, I think, positions herself very well within her book, and she identifies herself as coming from a Jewish background that is very aware of colonisation, but she absolutely does not see herself as able to speak from the perspective of a colonised person. So I'm quite happy with using those bodies of theories I mentioned, but I became aware that we're driving this particular article very much by the theorising, which is not Indigenous knowledge. But as a result of that, I think we've come to the view that we need to write a 3rd paper that is very much driven by the Indigenous voices. And Robin, I think you're going to draft that, aren't you? That's what I thought you'd know. Anyway, that's just on the drawing board. We'll do it soon, though, I think, and really try to. We need a paper that is more driven by the voices of the people that Robin and Sarah spoke with.
And just to finish with, Leanne had a slide about the summary, that we call it a summary, but it was maybe 4 or 5 pages long, where we addressed the major themes that came up in those interviews and responded to them with all quotes from those interviews. So that went back to all the people that we spoke with and their organisations, and we know that got shared amongst quite widely amongst the network of agencies.
Well, please join me in thanking you.